Unit 11 Banker Customer Relationship JAIIB Principles and Practices of Banking Module B. Page number 1. Banker. The Banker Regulations Act 1949 Section 5B defines a banker as a person undertaking business and banking. Banking means Section 6 accepting deposit from public from the purpose of lending and investing, repayable on demand or otherwise withdrawable by check, draft, order or otherwise. Important features of banking business. 1. Accept of deposits for lending and investment. 2. Acceptance of deposit from public. Cooperative society accept deposit from members, hence not bankers. 3. Acceptance of deposit of money only. Acceptance of deposit that are repayable on demand or otherwise. 5. Money lending are not bankers. 6. Individual cannot be bankers. Other important functions of banker as per section 6 are 1. Discounting of bills. 2nd. Collection of checks or bills. 3rd. Retainments. 4th. Hiring of lockers. 5. Conducting forex business. 6. Conducting government business. 7. Issuing the letter of credit or bank guarantees. Customer. There is no legal definition of customer but various judgments based on the section 131/131A of NI Act 1881. A customer means a person who to open account which bank accepts with proper introduction. When customer tends an account opening from to open the account and the bankers accept it, actual relationship is established. A person who only avails services like retainments, encashment of third-party checks as a payee without having an account is not a customer of a bank. Initial deposit. The initial deposit for opening an account may be cash, a check or no deposit even at the time of opening the account, as zero balance account can be opened. Who is a customer? Question mark. A person who maintains any type of account with the bank. It can deposit account, loan, safe deposit account, locker account, which is duly introduced as per Goiboria Committee recommendance. B. Even a person who fails the accounts opening from hands it take over the bank who accepts it. Acquire the status of customer. Action of the bank to formally open the account is a procedural requirement. C. A person who can treat as customer of a branch where the maintains any account. He cannot be treated as a customer of other branches of the other bank unless the bank has made an arrangement, particularly in case of CBS branches where customer is considered as customer of the bank. A bank maintaining any account with another account also becomes the customer of the bank. Customer for KYC policy. Customer for Know Your Company policy. As per RBI, Reserve Bank of India, December 2004, for KYC policies and customers may be defined as a person who entity that maintain an account with the bank and or as a business relationship with the bank. One of those whose behalf with account is maintained, that is the beneficial owner. Beneficiaries of transactions conducted by professional intermediaries such as stockbrokers, socialiters, solitors, etc. as permitted under the law. And fourth point, any person who entity connects with a financial transaction which can be pose significantly reputational or other risk to the bank, say a wire transfer or issue of high value demand draft as a single transaction. Important point. Introduction is not mandatory constitute a bank to be a customer. If he is a provider of approved documentary evidence of identity and address as per the RBI guidance of India of December 2012. Page number 2. Banker-customer relationship in different transactions. Transaction banker customer. Transaction deposit in the bank debitor customer creditor. Transaction loan from the bank creditor customer debitor. Transaction locker bank lessor customer lessee. Transaction safe custody bank bailee customer bailer. Transaction purchase of a draft bank debitor customer creditor. Transaction pay of draft bank trustee customer beneficiary. Transaction collection of check bank agent customer principal. Transaction pledge bank pledgee customer pledger. Transaction mortgage bank mortgagee customer mortgager. Transaction assigning instruction bank agent customer principal. Transaction sale/purchase of securities on the behalf of customer bank agent customer principal. Transaction money deposit but instructions are not given for its deposital bank trustee customer beneficiary. Transaction articles left by mistake bank trustee customer beneficiary. Transaction share given for sale bank share given for sales bank agent customer principal. Transaction assignment bank assignee customer assigner. Bank hypothetication bank hypothecate customer hypothecator. Bankers obligation next point. Bankers deal in public money and therefore various relationship with the customer impose certain duties on the banker. These duties are A. Duty to honor check of customer, details of which are in the given previous page under NI Act. Duty B. Duty to maintain sincerity of accounts. Next point. Termination of relationship. The relationship terminates when the customer closes the account after giving suitable notice whatever required. Second point. When banker closes the account after due notice of reason period which is compulsory and for which the banker may be held accountable for damage, if any, due to dishonor of checks. Third point. The knowledge of the death, insanity and insolvency of the customer. Fourth point. On garnishee order and attachment order. New point. Anti-money laundering. Money laundering is the process of converting illegal money of crime, that is illegal money, into legal legitimate money. There are three stages of money laundering. Placement of fund, physical disposal of the procedure of criminal activity. Second, layering, separating the money from the source of bank complex layering by financial transactions. Third, integration, that is bringing the laundered procedure into the legitimate economy as normal funds. Important objective of Prevention of Money Laundering Act 2002. To prevent use of banking system for money laundering by criminals, to put in place control for detection and the report of suspicious activities. Another point, know your customer guideline. The KYC principle, know your customer KYC principles were issued by RBI in August 2002 under Section 35A of the Banking Regulations Act 1949. These related to identification of depositor when the objective to prevent bank from being used. intentionally or unintentionally. The criminal elements for money laundering activities, the guidelines for applicable to all the accounts including foreign currency account transactions. Review of guideline. The guidelines were revised November 29th on 2004 in line with the recommendation made by the Financial Action Task Force FATF, Financial Action Task Force, and Anti-Money Laundering AML standards on the combating finance of the terrorism CFT. Opening of account. It's a new heading. KYC procedures should be the key principle for identification of an individual/corporate. While opening an account, the customer identification verification should be on the basis of documents of verification and the proof of the address provided by the customer. Introduction of existing customer is not mandatory. In the brackets. Page number 3. Document for individuals. For identity and address proof as per PML Act, passport, PAN card, voter ID, driving license, UIADI letter, MGNAR EGA job card, or low risk customer under a specified procedure, and the document can be 1. Identity card issued by government, bank, PSU. Second point. Letter issued by gazetted officer, RBI, July 17, 2014. It was issued. For low risk customers where account is opened without appropriate KYC compliance, complete verification of the identity must be done within 6 months. As per the RBI, address can be current or permanent. If address changes, fresh proof will be given within 6 months. In address change is due to the relocation customer of information within 2 weeks. Customer for companies. 1. Certificate of incorporate and memorandum and article of association, resolution of the board of directors and open an account, and identification of those who have authority to operate the account, power of attorney guaranteed to its managers, officers, etc. Document of partnership firms. 1. The registration certificate if registered, partner deed, power of attorney granted to partner by employees of the firm of transaction business and the behalf, any official valid document identification and partners and person holding the power of attorney and their address. 5th point. Telephone bill in the form of firm partners. Document of trust and foundation. 1st point. Certificate of registration if registered. 2nd. Power of attorney granted to transaction business on its behalf. 3rd. Any official valid document to identify the trustees, senator, beneficiaries and those holding power of attorney, founders, managers, directors and their addressee. Last point. Resolution of the managing body of the foundation / associate. Telephone bill. Cash transaction. New point. Banks are required to issue travel checks, demand drafts, mail transfer and telephonic transfer for 50,000 rupees and above only debit to customer accounts against check and not against cash. Small accounts. Government of India Notification 2010 December 16. The small deposit account means a saving account in a banking company where the aggregate of all credit and financial year does not exceed rupees 1 lakh. 2nd point. The aggregate of all the withdrawals and transfer in a month does not exceed 1 lakh and the balance at any point of time does not exceed 5 lakh rupees. Condition. Account can be allowed to be opened and possession of self-assessed photograph and affixation of signature thumbprint. Account shall be opened only at core bank Banking solution linked bank branches. Foreign remittances are not to be credited in small accounts. Account shall remain operational initially for a period of 12 months and therefore for the further period of 12 months if the holder of such an account provides evidences before the bank company or having applied for any of the other official valid document. Review after 24 months. Fine for violation of KYC norms. RBI have power to impose fine under Section 47A(1)(b) of the Banking Regulation Act 1949 in violation of KYC norms for the violation of extant guidelines of relating to IPO financing. Bank saving bank deposit accounts. Banks are advised by RBI August 2012 to offer a basic saving bank deposit account to replace the no-frill account. Account is a normal banking service available to all. No requirement of any medium balance. The service available include deposit and withdrawal of cash at bank branches, ATMs, receipt, credit card, money through electronic payment channel or mean by deposit collect of the cash by drawing the central state government agencies and departments. There will be no limit of number of deposit but the maximum 4 withdrawals will be allowed in a month excluding ATMs withdrawals and account is subjected to RBI instructions on KYC, anti-money laundering, AML, that is anti-money laundering, and opening bank account. If account opened on the basis of simply KYC norms, the account would be treated as a small account and would be subjected to conditions stipulated to such accounts. Money Laundering Act, obligation of banks. With effect from July 1, 2005, in terms of rules and under Prevention of Money Laundering Act (PMLA) 2002, Section 12, there are certain obligations on bank to preservation and report the customer account information for the RBI, which issued objectives during January 2006 U/S35A under Bank Regulation Act 1949 and Rule 7 of Prevention of Money Laundering Rule was as under the maintenance of record of transactions. The gross transaction of above 10 lakhs is equivalent to foreign currency. Series of cash transactions connected to each other of below 5 lakh rupees equivalent to foreign currency within a month. Aggregate value of such transaction exceed rupees in 10 lakhs. End of page number 3. Page number 4. Point C. Cash transactions in foreign and country-filed currency notes or bank notes where any forgery of a valuable security has taken place. Specious transaction in a cash or otherwise. Maintenance and preservation of records. New point. Bank should maintain for at least 5 years of the date of cessation and relation between the bank and the client and all necessary records of transaction. Both domestic and international will be permitted resurrection, reconstruction of individual transaction, including the amount of type of currency involved in it, so as to provide, if necessary, an evidence of precautions of the person involved in any criminal activity. New point. Reporting of financial intelligence under Unit India. Banks are to report informed relating to cash and specious transactions of the Director Financial Intelligence Unit India FIUIND and New Delhi banks should be adhered to the followings. Transaction coverage. Large cash transactions of rupees 10 lakhs. Name of the report CTR. Period 15 days of close of each month. Transaction coverage. Specious transaction. Name of report STR. Period within 7 days of reconfirmation of specious suspicion. Transaction coverage. Counterfeit currency notes. Name of report CCR. Period within 15 days of detection. Bank are to keep record of detail of these large cash transactions in a separate register. The principal office should record his reasons of treating any transaction in a series of transactions as suspicious. Banks are not to put restriction on operations in the account where STR has been made. November 2004 KYC policy. KYC standards. The policy should be incorporated with the key elements of a customer acceptance policy, B. Customer identification procedure, C. Monitoring and solution, and D. Risk management. A. Customer acceptance policy. Bank should lay down policy of the following aspects of customer relation in the bank. 1. No account is opened anonymous or fictitious benami names. B. Not to open an account to close or exist where the bank is unable to verify the identity proof, obtain documents as the risk categorization due to the non-cooperation of the customer and non-reliability of the data information furnished to the bank. Customer profile. Banks are prepared a profile of each new customer based on risk categorization. It will be a confidential document and detail contained therein shall not be divulged of cross-seeing or any other purpose. Risk consideration. The customer may be categorized into low, medium, high risk categories. Low risk customer. Individual other than high net worth with entities are source of wealth and can be easily identified in transaction whom account by the large confirmation to be known profile may be as categorized as a low risk such as a salary employee, low income data, government department and government owned companies, regulators and custody bodies, etc. In such cases, we basic requirements of the verification of a document and location of the customer are to met. Medium and high risk customers. Customers are likely to pose a higher than the average risk of the bank and may be categorized as medium and high risk bank and may apply enhanced due to the intelligence and measure of the case and non-resident customer, high net worth individual, trust, charitable NGOs and the other organizations receive donation, companies having close family shareholders and beneficial ownership, gems and sleeping partners, politically exposed person EPS for Asian for foreign origin, non-face-to-face customer and those who dubbed reputation as a public informer available, etc. Updation and risk reclassification. Banks to do review at least once in 6 months. Full KYC is required at least once in 2 years in the case of high risk customers, 8 years for medium risk customers, 10 years for low risk customers. Closure of bank accounts. When the bank is unable to apply in appropriate KYC measures, the bank may consider closing the account or terminating by banking business relationship after issuing due notice to the customer explaining the reason of the decision. Such decision need to be taken a reasonably senior level. Customer identification procedure CIP. Customer identification procedure. Customer identification means identifying the customer and verifying her identity by using reliable, independent source of document, data or information. Kind of information. For the customers that are natural person, the bank should obtain sufficient identification data and sufficient identification of the customer, her location and his recent photographs. For customers and a legal person or entities, bank should verify the legal status of the legal person entity through proper and relevant documents. Verify that person posting to act on behalf of legal person entity is end of page number 4. Page number 5. Continuing from page number 4. Second point, verification that any person supporting to act on behalf of a legal person / entity is so authorized, identify and verify the identification of the person. Third, understand the fellowship and control structure of the customer and determine who are the natural persons who ultimately control the legal person. If the bank decides to accept the accounts in terms of the customer acceptance policy, reasonable measures and should be taken to identify the beneficial owners and verify their her their identity in a matter so that it can satisfy that it knows who the beneficiary owner is slash are. Appointment of principal officer. New point. Bank may appoint a senior management officer to the designed as principal officer to be the located at the head slash corporate office of the bank. He shall be responsible for monitoring and report of all the transactions and the sharing of information as required under the law. He will maintain close liaison with the enforcement agency, bank, and any other institution which are involved in the fight against money laundering and combating finance of terrorism. CFT. Different types of products and services. This is a new point, new heading, new point. Different types of products and services. Deposit products. Bank offers 3 types of deposit products. One, that is current account, saving account, and term deposits. On current account, no interest is paid. On saving deposit, bank can pay interest rate to be fixed by them on a day basis, which was enforced from 1/4/2010. Different rates can be quoted for deposit of above 1 crore rupees. Term deposit. Minimum/maximum maturity period 7 days irrespective of the amount of the deposit. Normally the maximum period would be restricted to 10 years. Second, rate of interest. Rate of the term deposit scheme are same for all categories except the certain decision given taking into the account of a quantum of deposit known as differential rate of interest. Bank can allow either fixed interest rate or floating rate interest. Bank can also perform schemes meant by senior citizens above 60 years and above and pay higher interest rate than no other normal depositors. Premature withdrawals by paying interest at the same rate 1% less than the interest rate payable for the period under maintenance remained with the bank can be allowed, which is enforced from 1 May 1998. Which was enforced from will be enforced from 1/4/2013. Banks can refuse payment withdrawals in all terms deposit account, including of individual in respect of bulk deposit of rupees 1 crore. Payment in cash of term deposit. The term deposits can be paid in the cash where the amount is rupees 2 lakh rupees more. Section 269T of IT Act. This can be paid only by the way of credit to bank account or the way of account pay cross demand draft. Leasing is an account whereby the owner of the asset transfer the right to use the asset against payment of the fixed lease element. There are 2 parties in a lease contract. One is lessor of the owner and the other lessor to user. Lessee to or user. The lessor remains owner and lessee property remain in the possession of lessee. Leasing activity by bank. During March 1994, RBI performed bank to undertake business of leasing and hire purchase do not beyond 10% of their total advances. Period of lease. Lease is generally a fixed period fixed in advance. After expiration of the period of lease and the lessor can be purchased the lease property as agreement between 2 parties and the lessor contract is generally not cancelled. Rental. The lease rental are decided in the beginning of the lease period for the entire period, and the accelerated lease rental is leasing mean how low the beginning of gradually later on. Lease and hire purchase. A lease under brackets, which is Government of India Contract Act 1872, is different for the hire purchase, which is a contract of owner hire, and after the contract of the ownership is passed to the hire on payment of the amount. The assets of hire purchase appears in the balance sheet of the hirer and also claims percation in installments of partially treated as capital payment and the balance as interest into expenditure. Only the amount of interest is considered to fix for tax benefits. Terms in leasing. Lessor. A person who undertakes an agreement conveys to another person, the lessee, the right to use the return for tenant and asset for an agreed period of time. Let's see. A person who under an agreement obtain the another person, the lessor, the right to use in return of rent an asset for an agreed period of time. Lease, an agreement whereby the lessor conveys to the lessee in return of rent the right to use asset for agreed period of time. Finance lease. A lease is classified as finance lease if it is secured for the lessor the recovery of its capital period. End of page number 5. Page number 6. Continuing from the last line of page number 5. Finance lease. A lease is classified as the finance lease if it secures for the lessor the recovery of its capital quarterly plus a return of the fund invested during the lease term. Such a lease is normally non-cancelable and the present value of the minimum lease payments at the inception of the lease exceeds or is equal to substantially the whole of the fair value of the leased asset. Operating lease. A lease is classified as operating lease if it does not secure for the lessor and the recovery of his capital outlay plus a return on the fund invested during the lease term. Sale and lease back. A sale and lease back transaction involves the sale of an asset by the vendor and the leasing of the same asset by the vendor. The rent and the sale price are usually interdependent as they are negotiable as a package or it and may not represent fair values. Residual values. Value estimated at the inception of the lease asset at the expiry of the lease term. Merchant banking. In India, the merchant banking business started in the year 1967 when Grindelwald's Bank established their merchant banking division. What is the merchant banking? Merchant banking stands for the providing various services related to the capital market, investment and the financial to corporate sector. This includes not only the activity for the above purpose in the country but to at times arranging funds from outside of the country. Which service are provided? The merchant bank also provides consultancy and corporate sector on this issue like finance, capital, structure and investment, merge and take over the amalgamation and establishment coordination between the government and the corporate sector. Merchant banking services. A. Project counseling. B. Loan syndications. C. Technology tie-ups. D. Raising of fund from capital market. E. Raising of fund through new instruments like commercial paper, non-zero bond, warrants, etc. F. Portfolio management. G. Mutual funds. H. Bought out deals. 7. I. Rehabilitation of sick units. J. OTC market operations. K. Merging and amalgamation. Plastic card or plastic money. Plastic card are used as a medium of payment and are of different kinds and different features. These cards include credit card, debit card, smart card, etc. Credit cards. Being an instrument of payment, the credit card holder can obtain either goods or services from merchant established called point of sale without prior payment where such arrangements exist. At the time of purchase of a card slip, charge slip is prepared on the basis of which the payment is claimed from the card issuer bank and the amount of payable by the card holder to the issuer bank during a specified period. A number of parties are involved in credit card transactions and there is a contract between card issuer and the card holder. Under the agreement, the card holder is allowed to make use of the card at a specified retail outlets called merchants establishment to pay their goods and services. There is also another separate arrangement between the card organization and the member of establishments. Procedure. When a card holder makes purchase from specified retailer outlets, the retailer outlets make out bills to the account of the card holder and obtain payment from the card organization, which in turn makes a monthly bill to the bank which issued the card. The bank makes payment on the debit of the customer's account subsequently. The whole process takes about 30 to 40 days. During this period, the cardholder enjoys credit. Terms used in the credit card business. Point of sale, POS. Point of sale merchandise. Merchant establishment, where the card is to be used on purchase of goods and services. Charge slip or charge draft. The person Bill related to purchase of goods and services that are created by the merchant establishment and confirmed by the card holder as a proof of purchase of good of alignment and services. Floor limit. Discretion permission to the merchant establishment up to which it can be accepted the card payment. Card limit. Limit to which a card holder can use card on payment of the previous purchase. The limit is restored. Hot card. Lost, stolen or misplaced card. Hot list. Caution marked by the issuer bank against use of the card holder because of fault in payment. End of page number 6. Page number 7. Or default payment values. Chargebacks. The transactions which have been accepted by the card holder earlier but dispute later. Debit card. A debit card is also a payment card used to obtain cash, goods and services, automatically debiting the payment to the card holder's bank account instantly in which credit balance exists. Procedure. In a debit card, when the cardholder makes a purchase, the merchant establishment swipes the card in an electronic data capture machine which debits the bank account of the cardholder. The merchant establishment gets the payment before providing the goods or services. Requirement. A client need to have a bank account if he wants a debit card. In a debit card, the limit of the cardholder will be amount of fund he has in his account. Types. The debit cards are two types: personal identification number (PIN) being issued by MasterCard in association with the Citibank, and signature based being issued by Visa International in association with the SDFC Bank. Distinction between credit card and debit card. Credit card. It is a card that cardholder uses certain line, makes drawing within the sanctioned limit, makes payment on the receipt of the bill from the merchant establishment, make payment from any other bank account. Debit card, in other hand. In this card, the cardholder uses the balance of his account, use the amount available in his account, payment is made immediately on purchase, customer must have account of the bank. Smart cards. RBI defines smart card November 5th, 1999, a card or a function of a card which contains real values of the firm electronic money which someone has paid for advance, some of which can be reloaded in the future funds, or one can connect to the cardholder's bank account online. For payment through the such account which can be used for a range of purposes. The transaction includes prepaid cellular phones and a store value. These cards look like any other plastic card in an integrated circuit chip installed. The IC contains memory, a process of communicates with the outside world through contact on the surface of the card. The card may or may not have an intelligent memory chip or a microprocessor card. Process MasterCard are most situated for bank application, as these cards have a built-in memory and process. The protection of based on the data encryption standard in which is accepted by the International Standard Organization (ISO). Different types of smart card. Stored value card. These are also known as prepaid cards or value-added cards. Cards have magnetic strips on the or a computer chip in which value is stored. On the other hand, funds are directly debited from the card. Magnetic strip card. Conventional cards like ATM, credit card and all the magnetic strip cards, but smart cards in the form of magnetic strip can store much more information. Reloadable card. These are the cards where the value is replenished once it is used. Disposal cards. These cards have a specific value and once the value is stored, these are discarded. Closed card. These cards, the value in which is the use of the specific purposes like phone cards. Open cards. These cards used for several institutes and electronic purpose for electronic wallet. Electronic purpose. The electronic card have provision for use of different types of accounts of the air, and the facility is known as electronic purse. Each have a storage or separate amount. It's new method of paying which permits the bank to enter the inter-transaction market completely to the credit or debit transaction market. This cash is electronic purpose and cannot be spent in the purpose if reported as lost. Now it's time for short questions and answer for the quick review. Question number 1. Who is a banker? Answer. As Section 5C Banker of the Bank Regulation Act, the banker company means a company that transacts business of banking in India. Question number 2. Who is a customer? Where it is defined? Answer. Customer has not been defined by any act, but generally speaking, anyone conducting a bank transaction with bank is a customer. Question number 3. What is the RBI definition for customer under KYC norms? Under KYC, a customer is a person who entity that maintains an account with bank or his or her business relationship with the bank. Question number 4. What is the relation between the bank and the customer in different situations? Answer. Customer transit various kinds of business with the banks under various laws of the country. With the change in the law that government the transaction, the relationship also changes. Question number 5. What is the relationship in case of deposit? Debitor and creditor, where bank is debitor and a customer is creditor. Question number 6. What conditions are imposed on the depositor on use of money while depositing money with the bank? No condition is imposed. Bank is free to use it in the most beneficiary manner to it. Question number 7. What is the bank bounded to return the money deposited by the customer? If it is demand deposit or demand term deposit according to the term of deposit. Question number 8. If the bank fails to return the money deposited by the customer, bank is liable for the loss caused of the customer for its failure to return the money when demanded for the customer. That is the end of page number 7. Page number 8. Question number 9. What is the essential element of a draft made by the customer for obtaining payment of check? Answer. Demand must be in proper time, proper place, in proper manner. Demand after business hours is not proper demand. Question number 10. What is the mode of demand for withdrawal of money by the customer? Answer. Check, demand draft, withdrawal form or otherwise. Withdrawal form or otherwise. Question number 11. What is the security for the deposit given by the customer to the bank? Bank deposits are unsecured as bank do not give any security to the customer for deposits given to the bank. Question number 12. Whatever the law of limiting is applicable on the bank deposit? Answer. The bank deposit must debits the law of limitation is equal and applicable on such deposit. It's available for 3 years. Question number 13. Limitation is a case of demand deposit. It starts to run will be enforced from the date of demand. Answer. From the date of demand by the customer on the bank. Question number 12. Limitation in case of terms of deposit starts to run will be enforced from the date of demand after the term deposit matures. Question 15. Under the what circumstances the relationship between the bank and the customer is that of creditor and debitor? When the bank grants some loan, advance or overdraft to the customer, the relationship is that of creditor and debitor. Question number 16. Whether the law of limitation is applicable to loans and advancement? Yes. Question number 17. Limitation in the case of loans and advancement begins from different time period and runs from different time period from different transaction, depends upon the nature of loan and the society of security. Question number 8. If a bank is handled over certain share certificate for safekeeping the relationship that is of that bailee and bailer, where bank is bailee and the customer is bailer. Question number 19. What precautions is to be taken by the bank under such circumstances? A man of ordinary prudence would take in case of his own goods and security. Question number 20. If some loss is caused to the securities and goods when in the custody of the bank, who is liable for such loss? Answer. If the bank has not taken adequate care, bank is liable for deposit. Adequate care and loss of that has occurred, bank is not liable. 21. Bailee and bailer relationship is guided by which act? Indian Contract Act 1872, section 148. Question number 22. When the banker receives a check from collection of securities or deposited by the customer of collection of interest. What kind of relationship it is? Agent principal, where the banker function as agent. Question number 23. Agent principal relationship is guided by the which act? Various provision of Indian Contract Act 1872. Question number 24. What is the relationship of agent principal termination on death, insolvency and instantly of the customer on complete of the task? What is the relationship by the bank and the customer when the locker is rented? That is question number 25. Where the bank is lessor and the certain bank, it is also called licensor and licensee. Question number 26. If loss is caused to the customer in case of lessee relationship, who is liable? Bank is liable only when the loss is caused due to the negligence of the bank. Question number 27. What is the relationship between the bank and the customer in case of pledge? Pledgee and pledger. Question number 28. What is the relationship between bank and the customer in case of mortgage? Mortgagee, mortgagor. 29. What is the relationship between bank and the customer in case of standing instructions? Agent principal. Question number 30. What is the relationship between bank and the customer in case of money deposited by mistake? Trustee and beneficiary. End of page number 8. Page number 9. Question number 31. What is the relationship between the bank and the customer in case of purchase of a draft? Debitor, creditor. 32. What is the relationship between the bank and the customer in case of pay of a draft? Trustee, beneficiary. Question number 33. List out two obligations of bank towards customer. Answer. To honor check issued by the customer and to maintain sincerity of affairs of his account. Also to make secrecy of his account. Question number 34. If more than one check issued by the customer are presented simultaneously, but balance is enough for one check, one only, which check should be passed? Right order of priority. The payment of check is made by discharging maximum liability of the customer. The order of the following is the first payment of the government dues, then the max of the checks, that's high value which discharge maximum liability of customer. Therefore, the date and the lastly printed earlier number. Question number 35. A customer closed the account with a bank. What is the obligation of the bank regarding disclosure of affairs of customer's account? Bank's obligation to maintain secrecy continues even when the account is closed by the customer. Question number 36. When bank can refuse payment of a check, write four instances. Insufficient balance / death / lousy / receipt of the garnishee of or attached order. Question number 37. Duty of the bank to maintain secrecy of the customer's account in terms of Section 13 Bank Companies Acquisition and Transfer of Undertaking Act 1970. Question number 38. Write down the circumstances under which the bank can disclose the affair of customer's account. Answer. In the interest of bank / public or under implemented consequence / under banking practices / law. Question number 39. U/S 313 of income tax. What kind of disclosure can be made by the banker? Answer. Bank can examine on oath and ask to produce book. Question number 40. U/S 1336 of Income Tax Act. What kind of disclosure can be made by banker? Generally, inquiry says that cash transaction can be above 1 lakh. Question number 41. Section 45B of RBI Act deals with what kind of disclosure related to bank customers? Can all credit information the bank? Can call credit information from bank? Question number 42. What is the nature of banker's obligation regarding disclosure, absolute or qualified? It is qualified as under certain circumstances. The banker is required to disclose the affair, say under provision of law. Question number 43. What state various law and relevant section where the information regarding to customer's account is closed by the banker. Income Tax Act 1961, Section 131 and Section 133/6. Companies Act 1956, Section 235 and 237. Bankers Book Evidence Act 1891, Section 4. RBI Act 1934, Section 445B. Foreign Exchange Management Act. Question number 44. Can the bank disclose information about the loan of the customer to the guarantor? Without express authority of the borrower, bank cannot disclose. Question number 45. If a bank is required to disclose the information about the customer, which 2-3 precautions the bank must take? Only relevant information to be provided. Information should be provided in general terms. Information should be provided without any engagement of the party or the bank. Bank should clearly state bank would not be liable for use of this information. True false. State whether the following is true or false. Question number 45. Banker's obligation regarding payment of the check is conditional. True. For question number 47. Individual, partnership, firm and joint stock companies can be undertake business of banking. False. Question number 48. Bank can disclose the affair of customer's account after closing the account. False. 49. Ledger keep can disclose the balance of account of customer to a third party is permitted by the customer. True. Question number 50. Bank can also function as executor for and on behalf of the beneficiary customer. True. End of page number 9. End of the chapter.